also write down the points on the side. I don't know if I think Siddharth also is planning to just speak in case I'm not mistaken.
We are
Okay.
now live on YouTube.
Okay. Okay.
Okay,
Great.
Sarah, there is a white window. Somebody have like, I don't know, like the blackboard.
Ah,
Okay.
okay.
I was
It's
just trying
yours.
to,
It's Meta?
That's
Okay.
Siddharth. Yeah. Yeah.
Okay.
because I was just trying to look for a way I can actually share this, my
Okay,
PowerPoint.
don't worry about it. And also it's Maria Camila who is going to help us with the translation.
Yeah.
Thank you, Maria Camila. So we are
Hi,
already in
everybody.
video. We are in YouTube. Then we can share also the link. Thank you for being here, Siddhartha and Meda. We are going to have the first session that related with India, that
Yeah.
is the basic structure doctrine in India. That is very a special topic, and also that is a very important topic related with the unconstitutional of constitutional amendments. The beginning of the doctrine was in India in 1967 with Golab Nath versus State of Punjab decision, and then with Kesanabanda Bharati versus State of Kerala in 1973. They made the doctrine, or they named the doctrine, no? They named the doctrine basic structure doctrine. And it's a pleasure for us to have you both here. Siddhartha now is in New Delhi, and Meda is in Oxford. So it's a very also
In Germany. In Germany.
now you are in Germany.
Yeah.
Okay.
Now in Germany. Yeah. Yeah.
Okay. In which city? In which city?
I'm in Frankfurt currently.
Okay. So it's
Yeah.
very cold.
Yes.
Okay.
Oh yes, very cold.
And what
Yeah.
about the temperature in New Delhi, Siddhartha?
Currently, I'm in my home city, which is Gwalior, which is in the central part of India, and the temperature here is about 15 degrees Celsius. So it's a
Okay.
bit cool for us here.
Okay. So I'm going to do a little presentation. Meda is a researcher and pursuing her PhD in the area of judicial accountability and performance evaluation at the Humboldt Universitat in Berlin, under the direction of Professor Philip Dan.
Yes.
And now she graduated from the master from the University in Oxford in 2014, after she worked as a lawyer in India in the area of administrative and civil law. Before pursuing her PhD, Meda has also worked in a legal policy think tank in the area of judicial reforms in India. And Siddhartha, who I met in New Delhi 2 or 3 years ago, he is graduated from Amit Law School in 2015, and thereafter joined the Chamber of Constitutional Jurists. Like Mr. Dayurinia has an associate lawyer. He has assisted Mr. Anju Ruhina in leading constitutional case concerning death penalty, executive powers, rival disputes, human rights, etc. Before the Supreme Court of India. In 2016, Siddhartha was appointed by the government of Maharashtra to represent the state before the Krishna River water dispute. That is very important also decision that also we have also a decision related with the Atrato River here that is similar to this decision related with the natural rights. Tribunal constituted to adjudicate the dispute concerning river water sharing between 4 neighboring states. In 2017, Siddhartha attended Central European University in Budapest to pursue a master in comparative constitutional law with a merit-based scholarship. After successful completion of his master, Siddhartha returned to India and has been practicing as independent counsel before the Supreme Court of India and the High Court of Madhya Pradesh, where he represents clients in constitutional, commercial, and criminal cases. So thank you both for being here. This session will be in English, but at the end we are going to have a little translation from the presentation, like a resume, very short, about the main ideas that Meda and Siddhartha shared with us. And then when we finish the first hour, we are going to have like a little time to do some questions from the public. So we have like here a chat from questions and answers, and we are going to see the questions. And if somebody is going to want to do the questions in live, so it will be perfect, we can do it. I'm going to speak a little bit in Spanish. Gracias por estar aquí, y esta es la 17ª sesión del Seminario de Poder Constituyente y Reforma Constitucional, y estamos con Meda y Srivastava y Siddhartha Sijoria. Ellos van a hablar sobre la estructura básica de la Constitución, o la doctrina de la estructura básica de la Constitución en India, Basic Structure Doctrine, que consiste en que, a pesar de que la Constitución de la India no tiene cláusulas pétreas, la Corte Suprema de Justicia desde 1967 ha venido declarando inconstitucional reformas constitucionales, con el caso Golab Nath y después con el caso Kesanabanda, donde bautizaron la doctrina como la doctrina de la estructura básica en 1973. Presentamos a Meda, ella está haciendo ahora su doctorado en la Universidad de Frankfurt, estudió su máster en Oxford y bueno, se ha desempeñado también como asesora en una think tank en India. Y Siddhartha, pues lo conocí yo en Nueva Delhi, cuando estuvimos allí varios profesores en un seminario sobre la estructura básica de la Constitución en Jindal University. Y Siddhartha pues es abogado y ha asesorado casos que tienen que ver también con los ríos, y bueno, y también hizo su máster en Derecho Constitucional Comparado en la Universidad de Budapest, que es un máster muy famoso, y ha conocido a algunos amigos colombianos allí, y both of you are invited to know our country. So we begin with who wants to begin. Bueno, voy a decir un poco, vamos a hablar en inglés toda esta hora, y después vamos a hacer una pequeña traducción con algunas ideas básicas, digamos, de lo que cada uno dijo, muy corto, para después dar paso a las preguntas del público, ya sea en inglés o en español, para poder así que los profesores nos contesten. Si alguno quisiera pues subir, digamos, hacer la pregunta en directo de viva voz, pues nos puede informar y nosotros lo habilitamos. Who wants to begin?
I would begin.
Okay, Siddhartha.
So, hi everyone, and I want to thank Gonzalo for this opportunity and for this invitation to speak on the very relevant issue, because India and Colombia share a very good relationship when it comes to the constitutional structures, because I think both courts follow the same doctrine when it comes to constitutional amendments, as well as both courts are one of the strongest courts in the world. And I'm also very glad that I'm able to share this forum with Medha, who I have known from many years. And it's a pleasure that I'm able to speak on this issue along with her. Now, like I would discuss in this discussion, I would mainly focus on the evolution of basic structure theory in India and how it grew in India. And Medha would be reflecting upon a very interesting issue concerning the judicial independence and how the Indian Supreme Court interpreted the original constitutional provision in such a manner that it was against the literal interpretation of the provision, but it came and it was read as a provision that saved judicial independence as a basic structure of the Constitution. So to understand the issue of basic structure doctrine in India, we first need to understand that Indian Constitution came into existence in 1950, and it contains 25 parts, and for the present purpose, we will only focus on two parts of the Indian Constitution, Part 3 and Part 4. Part 3 of the Indian Constitution deals with the fundamental rights, and Part 4 deals with the directive principles of the state policy. Now, directive principles of the state policies are the duties which are imposed upon the state for deter for pursuing some goals which are important and which are non-justiciable. But still, it is the duty of the state to achieve those fundamental goals. Now, this is very relevant for the present discussion because basic structure doctrine, when it was introduced, it was a direct conflict of Part 3 versus Part 4. Now, when Indian Constitution came into, uh, so in all, India gained, like we all know that India gained its independence in 1947, and can you hear me? I think.
Yes, we can hear you.
So I was just about to discuss that if you look at the screen, you can see that Article 13 of the Indian Constitution has been declared. If you can see what Article 13 says, if it's visible. So when India wanted to achieve the goals, and when India gained its independence, it wanted to make laws for achievement of the socio-economic goals, and it wanted to enact laws for getting land and for achieving socio-economic goals. So when the Parliament of India passed several enactments where they wanted to take away the land, where they wanted to take away the property. And when this law came into existence, the law was challenged on the ground that it is directly violating the fundamental right to property, and it was challenged before the Supreme Court on several occasions and other courts. When these parliamentary enactments, which took away the rights of the people, particularly the right of the property, was challenged before the court declared them unconstitutional. The court declared them unconstitutional on the very ground that, if you can see on the screen, if you can see that it says that all laws, Article 13 says that all laws enforced in the territory of India immediately before the commencement of the Constitution, to the extent that they are violative of fundamental rights, shall be declared void. And the second clause, if you read it, it says that the state shall not make any law.
Excuse me, Siddhartha, I don't know, but someone wrote that he cannot see the presentation. I can see it. See it is no problem for me to see it, but I don't know if someone in the public can tell us if cannot see it. Because
Okay.
for me, it's okay, I can see it.
Okay, because Sarah is sharing this with me, for me.
Yes.
Okay, is it visible now?
Jonathan Narvaez, see that is black, but I don't know the other persons. Juan Londoyon, he said that he's okay, so I don't know. Maybe we can help Jonathan, but it's okay. You can continue. Thank you.
So I was saying that when these laws were introduced by the parliament and they were challenged on the ground that they are violative of fundamental right because of the definition which is given in part 13 part 2, if you read that the state shall not make any law which takes away or abridges the rights conferred by this part. So when the state introduced laws for the land reformation, they were directly in conflict with the fundamental right to property, and they were declared unconstitutional. So the state felt that it is unable to achieve the social goals because if they introduce any laws, then they would be declared unconstitutional basing on our definition of Article 13(2), which declares laws that are inconsistent with the fundamental right to be unconstitutional. Now, in order to circumvent this situation, the parliament enacted the first amendment to the constitution, and the parliament enacted the first constitution, and according to this amendment, a new schedule was added to the constitution, which was Schedule 9. And along with that, Article 31A was added to the Constitution, which said that if Parliament makes a law and put that in Schedule 9, that law could not be questioned on the ground that it violates the fundamental rights. Now, when this law was introduced, it was again challenged before the court, and the petitioners who moved the court came up for the first time with the argument that there are implied limitation on the power of the state, that they cannot introduce any law which is taking away the fundamental rights of the citizens, which is particularly the right to property. So in this case, when this law was introduced by the parliament, it was again questioned, and it was but this time, rather than declaring it unconstitutional, the court for the first time said that these laws are not unconstitutional, but rather they are constitutional, because if you read the definition of Article 13, it only declares that laws that abridges the fundamental rights are violative. But in this case, it is not a law, but it is a constitutional amendment, which is different from a law. A constitutional amendment becomes the constitution itself and ceases to be a law. So only on this ground, the Constitutional Court declared that the fundamental right in this case could be abridged for achieving the goal of the constitution, which is the goal concerning achieving socio-economic rights, which is given under Article 13.9, which was one of the socio directive principles of the state policy. Now, if you look what the court reasoned in this case was, the court said that though amendment was a law, but there is a difference between legislative and constituent power, and the word law within the framework of Article 13 did not include an amendment of the Constitution made an exercise of constituent power. Now, interestingly, one has to see that in Indian Constitution, Parliament is described as the constituent authority and not the legislative authority or a constituted authority. So this was the first case where the court came up with the theory that whatever the parliament does in capacity of a constituent body, that cannot be questioned because it is exercising the power which is exercised by the original constituent authority. Now, the parliament and the court came to this conclusion on two grounds. The first ground was that this amendment came in 1951. At that point of time, the original Constituent Assembly was continuing as the first parliament, as the interim parliament. And because it was continuing as the interim parliament, the court said that if the original framers of the Constitution has made this amendment, it cannot be questioned and it cannot be challenged that it is violative of the basic structure or it is violative of anything in the Constitution, because it is the constitutional giver himself who have come up with this amendment to the Constitution. So now, when this judgment came into existence, it was declared to be constitutional. It was allowed. The Parliament made several laws and put them in the 9th schedule, which allowed the Parliament to make laws and insulate them from judicial review. Secondly, this law held the ground for more than 17 years. And again, in 1967, the amendment to the Constitution was challenged again on the ground that basic structure theory requires, or the basic structure theory requires that no amendment can be made that takes away certain basic features of the Constitution. And since the fundamental right is permanent in terms of how the Constitution drafters required it to be, therefore, all the amendments which have been passed until now can be challenged on the ground that they are violative of the basic structure theory. And for this, the petitioners who have challenged this amendment came up with a very interesting argument. They said that if you look at the page 3 of this slide, if you can see this slide, if Sarah can move it to the third slide, third page, fourth, sorry, last. Can you? if you look at this, the original constitution looked something like this. It said procedure for amendment, and the first clause read amendment to the constitution could be initiated through, and something followed after that. So what the court in this case declared that there is a basic structure. The court in this case declared that, look, amendment is to be understood as a law, and amendment cannot be considered as violative, or amendment cannot violate fundamental rights, because amendment is a law. And if you look at this article 368, it only defines the procedure for amendment, and the power to make laws has to be found elsewhere. And if you can move to the third slide, this. So if you the one that read 248, 245, yes, this one. If you look at this slide, it declares that the parliament has the power to make laws, but those laws have to be subject to the constitution. So the parliament said that the constitution only defines the procedure for the amendment, but the power to amend the constitution has to be found in Article 245. And Article 245 declares that any law that is made has to be subject to the constitution, and if an amendment has been passed, it has to be subject to the constitution. Therefore, no law can violate fundamental right, because amendment to the constitution is to be considered as a law, and a law cannot violate fundamental right. So this is how the second case where the court declared that fundamental rights are the basic features of the constitution, and relying on this Article 245, they said that 245 limits the power of the parliament to enact the constitution, because this restrict, and this is a limitation, express limitation on the power of the parliament to enact constitutional amendment, which takes away fundamental right. So if you look at it from this perspective, for the first 17 to 20 years, the whole idea was the court considered that basic feature only means the fundamental right, because Article 13 defined no law can take away fundamental right, and thus any law that violates fundamental right would be considered to be violative of the constitution. Now, when Parliament declared that there is a limit, when the Constitutional Court declared that there is a limitation on the right or on the power of the Parliament to amend the constitution, that was not taken very well by the Parliament, and a lot of protests happened against the court for limiting the right of the Parliament to enact laws, because according to the government, there was nothing in the constitution that declared or that said that the Parliament's right can be curtailed, or Parliament cannot change the constitution, because amendment itself means changing the structure of the constitution. Now, this was the case where there was a lot of protest, and government, in order to in order to overturn the verdict in the Golaknath case, they came up with the 24th, and they came up with 3 amendments. Now, these 3 amendments were only concerning overruling the verdict of the Golaknath case that declared limitation on the power of the Parliament. And the court replaced the word procedure for amendment with power of amendment. And then another amendment was introduced, which reintroduced the first amendment that made certain laws and insulated them from judicial review. So when the word power was inserted in the constitutional amendment, the government, this amendment were again challenged by the petition by Keshwanandan Bharati, who was a saint guru in India, and his property was taken by the government by these enactment, and particularly by this amendment. So he came to the court and he challenged these amendment on the ground that they violate the principle that Parliament cannot take away the fundamental right, and also they are in violation of the Constitutional Court ruling that limits the Parliament power to enact law in violation of fundamental right. So Keshavanandan Bharati case is also known as the fundamental right case, because in this case, what happened was the court said that Parliament can change anything in the constitution. It can amend anything that is the part of the constitution, but it has to see that the basic structure or the basic features of the constitutions are not changed. Now all the people who are viewing it from Colombia would know and what the court declared in the third re-election case, where president wanted to get re-elected for the third time, but the court said that there are certain features of the constitution which cannot be replaced, and if another re-election is allowed, it would be in violation of the democratic principles, because certain features of the Colombian constitution forms the basic structure or the basic features of the Colombian constitution. Now, similarly, Indian Supreme Court in the Keshavanandan Bharati case came up with the idea that Parliament, the constitutional amendment is not a law but an amendment, and it subsumes the character of the constitution itself. So, Parliament amendment can take away the fundamental right, but it cannot violate it in such a way that it takes away or it replaces the constitution in such a way that its identity is lost, a new one has been put into place. So you cannot change the very structure of the constitution as it exists. So this was the basis in how the constitutional court in India came up with the theory of basic structure. And until now, it was considered that basic structure doctrine was only restricted to fundamental rights. Because if you already saw Article 13 put a restriction on the laws, that law cannot take away fundamental right. And when Keshavanandan Bharati case or the basic structure case came into existence, it was declared that this case is only in relation to fundamental rights and it does not extend to anywhere. This is very similar to Colombian Constitutional Court cases, but the problem with this decision was that it did not specify what constitute basic structure, but it said that it is to be decided by the courts in the coming times, and it is not an exhaustive list but an illustrative list, and the courts in future would look at amendments and then decide about the amendment and whether it is violative of basic features or not. So when we look at the Colombian decision, they have a 7-layer test, but in India there is no test, and there is wide scope of power given to the court to decide what is basic and what is not basic to the constitution. So until now, we have seen that the basic structure theory or the amendment to the constitution were only concerning the fundamental rights, particularly the right to property and their violation. And this decision of Keshavanandan Bharati case came in the year 1973. After that, in 1975, the then Indian Prime Minister Indira Gandhi had lost her election. And then she hadn't lost her election was declared to be invalid by a court in India, because according to the court, she has indulged into illegal activities or electoral malpractices, which declared her election to be invalid. This happened in 1975. And then after that, emergency was imposed in India, which continued for a while. But in order to overturn the effect of that judgment, the Parliament came up with another amendment, which was Amendment number 39 of the Constitution. And this was a very, very different and a very authoritarian amendment for the first time, because it not only dealt with any fundamental right, but the direct effect of this amendment was that it validated the election of the prime minister, because the prime minister in this amendment declared that any pending election petition against her would be declared null and void, and Parliament and no court which is already deciding any petition concerning the election of the prime minister would be valid after this amendment, because the parliament would constitute another forum for deciding the disputes concerning the election of the prime minister and anything which is pending before the court before passage of this amendment would be declared null and void. Now, this was very authoritarian because the direct result of this amendment was to declare something legal, which was declared illegal. And for the first time, the amendment was questioned on the ground that it violates the principles of democracy, violates the principle of fair and free elections, and also equality, because the equality of law demands everybody equal before the eyes of law. But this amendment makes the prime minister stand above the courts and other people. So this amendment came to be questioned before the court, and primary argument was that this amendment violates the principle of democracy because uh, this amendment violates the principle of democracy because what the amendment does is, rather than legislating, it acts at the court itself, because it is invalidating something which was invalidating the decisions of the court as a appellate forum, and parliament does not act in the judicial capacity. This was challenged on this ground that the parliament acted like a legislature and parliament violated the principles of democracy. Again, the court declared this amendment to be unconstitutional because it found that this amendment was directly in conflict with the democratic principles. And in India, Parliament cannot act as the judicial body, because if this amendment was allowed, it will be violative of the principles of separation of power, which is one of the essential features of the Indian Constitution. Now, interestingly, what we find in other courts and what was missing in India is that there has not been any discussion on the ambit of the word constituent and constituted. If Sarah could put Article 368 on the screen. Yes, if you read, it says that power of the parliament to amend the constitution and procedure thereof. And it starts with, notwithstanding anything in this constitution, parliament may, in exercise of its constituent power. So it is the constitution itself that makes the parliament constituent authority. So nowhere in the Indian jurisprudence it was discussed that what is this power of the constituent authority means. When the constitution itself makes the parliament constituent, then what restricts the power of the parliament to enact a constitution that may be violative of basic structure or any other feature of the constitution? For this amendment, there was one dissenting opinion in this case by one Justice Ray, who had come up with a very interesting argument. He said that though the parliament has acted in a judicial capacity, but parliament could act so because constituent power wields the power of judiciary, executive, and the legislature. And if the constituent power acts in its judicial capacity, it cannot be declared to be invalid or unconstitutional, because parliament, by the definition of itself as a constituent authority, wields the three power. It can also act against the constitution it can also act in a way that it can invalidate the court's decision. And it also relied on the Australian Constitutional Court, Australian Constitution, and the British Constitution, that gives certain judicial powers to the parliament. But it said that the constituent like in this case, but this judge also came up with this argument that the constituent power does and though wield the judicial powers, but in this particular case, it hasn't followed the legal norms which it itself created, which is equality before the law. Therefore, the court declared this amendment to be unconstitutional, and the court said that parliament cannot act against the democratic principles which violate the fair and fair elections in the country. Now, this is how the abusive constitutionalism argument came in the Indian structure. But this decision was against the parliamentary will, because parliament considered that this violates the right of the parliament to amend the constitution, because Parliament, as under Article 368, is the wielder of the constituent authority, and there is no limitation in the constitution. And this decision of the Keshanandan Bharati case, or the basic structure doctrine, is unfounded within the constitutional structure. So in order to nullify the basic structure doctrine, the Parliament came up with the 44th amendment in the constitution. Now this 44th amendment was very interesting, because according to this amendment, the constitution, the Parliament enacted two more provisions in the constitution. And in order to nullify the effect of basic structure case, the court said the power, or the amendment to 368 said that the power of the Parliament to amend the constitution is unlimited, unfettered, and any amendment that is made to the constitution cannot be challenged in the court of law on the ground that it violates the basic features of the constitution. Now, this amendment was directly considered as a violation of basic structure and was challenged in the court on the ground that it is authoritarian, it takes away the right of the court to adjudicate upon disputes, because judicial review is a basic feature of the constitution, and Parliament is a creation of the constitution. And earlier the court have declared supremacy of the constitution to be one of the basic features of the constitution. Therefore the court said that therefore the court came up and declared this amendment also as unconstitutional, because you cannot take away the right of the judicial review that is with the court. And if you do that, then you violate one of the basic features of the constitution, that is separation of power. Interestingly, even if you look at Article 368, it uses the term Parliament acts in a constituent authority. But despite that, the court declared that limited amending power of the Parliament is also a basic feature. So in India, they have also recognized that limited amendability by the Parliament as a basic feature. So now the court have, because of the definition of the Parliament as a constituent authority, the court completely nullified the effect of the judgment and the court of the amendment, and the court declared that no amendment can declare, or no amendment can take away the basic features of the constitution, and nothing can be done in the constitution that violates principles of democracy. In this case, which is the Minerva Mineral case, another amendment was considered by the court, which was, the court said that now anything which is done by the Parliament for the court the Parliament inserted another amendment, and this amendment said that if the Parliament enacts a law for achieving the goals of directive principles, then it will be considered valid and it will not be declared unconstitutional on the ground that it violates the fundamental rights. Now, this amendment was questioned, and this amendment was also declared unconstitutional, because the court has said that if you allow this amendment, then the government would make anything under the sun to become the part of the directive principles, and in turn the government would act authoritarian, and this will allow the constitution to become more authoritarian than democratic. And on this ground, this amendment was also declared to be unconstitutional. And now after this, there have been several constitutional amendments that have been made, that have been declared to be invalid by the court, and the court have itself wielded power that it now can declare anything under the constitution which the Parliament amends to be unconstitutional. And my view of this amendment and the power of the amendment in India has been that if you look at the Indian cases which deals or which concerns with the basic structure theory, particularly the Keshanandan Bharati case, these judgments run in more than 2,000 pages, where there are several opinions which are given and which are made, and it is very difficult to come out with a conclusion that what is the ratio or what is the reason for which the court came up with the theory of constitutional theory in India, because there is no meeting point in some of the cases. But because if you read all these cases, one thing becomes clear, that the parliament, if it enacts anything that the court finds to be unconstitutional, it can declare it to be unconstitutional without having any yardstick to follow. Because unlike other constitutional courts in India, there is no yardstick or there is no test which is evolved by the constitutional court to decide if any particular amendment is valid or invalid. So I think after this, I think Medha would be able to give more information or could contribute to the idea of how court has itself dawned upon itself power to declare anything as unconstitutional. Because the court, in one of the, like I earlier said, the court have allowed itself to become the only authority to appoint judges. And in India, the judges only appoint the judges against the will of the constitution. And the court changed the meaning of the constitution entirely in order to secure itself a independence judiciary. So I think Medha would be able to contribute on how the court misuses its powers in the constitution. Thank you.
Can I start, or would you like to translate that, Gonzalo?
No, vamos a empezar. We are going to begin with you. So
okay.
At the end, we can do
the translation.
A little bit.
Yes, of course. Yes, it's a very long discussion, so I understand. Okay, so all of you can hear me clearly. I hope that's all right.
Everything is okay.
Okay, great, wonderful. Thank you so much for that, Siddharth. I think you've done the hard job of giving the entire background. So I'm actually going to talk about a very specific sort of negative consequence of this basic structure doctrine. Just to give you a fair idea, I'm essentially going to be criticizing the judicial appointments process in India from the point of view of this basic structure doctrine and using judicial independence as my main point of criticism. So just to give you a broad idea, I'll be speaking on 4 points. I'll try to stick to that. I'm going to talk about the old law relating to judicial appointments. Then I'm going to talk about the new law. That's the second part. And then thirdly, I'm going to try and in a brief way criticize what the government was trying to do and also bring in a bit of comparative literature there, because I think for me, reading about Colombia was a very new and interesting thing. And I think the comparative bits between Colombia and India were very helpful for me as an Indian scholar, also writing my thesis on this issue, on the issue of judicial accountability. And I'm going to conclude by sort of pointing out certain interesting things that I understood from the Colombian jurisprudence, which I think India lacks and could benefit from. So I'm going to start with judicial appointments in India. Now, I think at the outset, it should be made very clear that our constitution has a very basic provision for judicial appointment in which it very clearly says that the Chief Justice of India is going to appoint, the president will appoint the judges in his hand and he will consult the Chief Justice. So essentially, without getting too lost in the technicalities, the essence of this is that basically the president in India is the one who is formally responsible. He will sign off on the documents and therefore sort of validate that a judge has been appointed. But the interesting part is that the language of the constitution says that he has to consult the Chief Justice of India or the Chief Justice of High Courts and the governors of states, as the case may be, because India is a federation of states. So interestingly, the judiciary in, I think, sort of starting from the 1980s, dealt with a series of cases, a series of litigations where a lot of judges were being transferred within the country. So we have a system where the Supreme Court is at the top, and then we have high courts for all the states of India. And these together make up the higher judiciary. So essentially, judges from one high court to another were being transferred, and this became very controversial because sort of there was a discussion within the judiciary that why are these transfers happening? Is there a political reason? And so these series of cases started in India, which were called the judges' cases. So they're called the three judges' cases. And they're the most significant cases to understand why judicial appointments work the way they do. So just in a nutshell, essentially what was decided in these cases was that in the first case, it was the court essentially interpreting the constitution in a very basic way. It basically stuck to the plain language of the constitution, which a lot of scholars say was sort of the good interpretation, but that's also up for debate. And they essentially said that in consulting the Chief Justice of India, when you appoint a judge, it's just a consultation in the plain sense of the word, which means that Chief Justice can reject an appointment, but if the president ultimately agrees that a certain judge is to be appointed, that he will sign off on it, and that's the end of the story. This drastically changed in the second judge's case, which largely in India is seen as the point at which the judiciary began to reclaim its power. So, in this second judge's case, essentially what happened was the bench of judges decided that there is too much power in the hands of the executive government to decide who and which judge will be appointed. So they decided to go into a very doctrinal understanding of the word consultation. So in the constitution, when it says that the president has to consult the chief justice, they, through a very long, very detailed judgment, ultimately decided that this consultation will appoint to a concurrence, basically a concurrence of opinion. And what emerged as relevant jurisprudence from this case was that essentially the Chief Justice of India is the most important constitutional dignitary who will decide which judges to be appointed. And as Siddharth mentioned before, essentially this was the turning point where the judicial appointment system in India was set in stone. So it was decided that it is this Chief Justice who will decide whether or not the executive government has a difference of opinion. That's what the judge is going, that's how judges will be appointed. And it's also important to mention that this was a very reactionary approach of the Supreme Court, because for a very long time, especially under the rule of Indira Gandhi, when she declared the emergency, which is very famous, very written about in Indian scholarship, it was essentially decided by the judiciary that they need to reclaim this power. They need to ensure that it's not the government who is dictating which judge is to be appointed. And their basic reason for doing this was because they said judicial independence is a basic structure of the constitution. This is, I think, where, as we infamously say, the story started, the problem started. And this decision was subsequently also confirmed in a third judge's case, where, there was a reference made to the Supreme Court of India to reconsider its view and whether this was good law. But the Supreme Court said this is essentially what it should be. So it's basically a group of judges which will decide whether a judge will be appointed. If the government doesn't agree, they can take that into consideration, but ultimately it's the judiciary's decision. And at least for me as a constitutional scholar, I saw that this was the point where, at least theoretically, there was a 180-degree turn in where the power lay. So I think the judiciary, like I keep saying, was reclaiming some of the power, some of the authority that it had. And this is the way that it at least in theory, the judiciary thought that it was taking back sort of this authority. And so this went on for up till 2014. This was sort of generally how judges were appointed. Of course, there was much criticism. People said that the judiciary is becoming corrupt, the judiciary has no accountability. And of course, one of the drawbacks is that it's a very famous criticism, sort of off point, but it's mostly upper caste male members of society that run the judiciary. And they are the same people who again and again elect the same kind of members, and there's a lot of nepotism. So the government thought the solution was a constitutional amendment. So in 2014, the 99th constitutional amendment was carried out, where there was a very significant addition to the constitution in the form of article 124A. So I'm sorry, I don't have the provision, but I also think, just to avoid getting lost in the wording, suffice to say that basically they decided that instead of just the chief justice, and 3 or 4 senior judges, there would be a commission. Now, I think most of us, if we've read about judiciaries across the world, we are familiar that a lot of countries have this system where there's a commission of different members of the judiciary, executive, law ministers, and sort of external members who select judges. It's common in South Africa, it's there in most countries in Europe. It's very debated, but we can agree that it's a very common way of choosing judges throughout the world in democracies. So India decided to follow suit, and they drafted this law where there was a commission which would consist of the Chief Justice, senior judges, also the law minister, which was the controversial part, and eminent persons. Now, I think at the outset, it would also be fair to criticize the law itself, because I think there has to be context also here. For example, in India, there is a lot of political influence on the judiciary. And even though it's a relatively mature democracy in many ways, I think because of the diversity of the country, I often feel India behaves as a very new and young democracy, which in some ways it is. So what happened was there was a huge controversy about how having a law minister on the commission which would select judges would lead to inevitable bias, because it's very open that there are a lot of political interactions within judges and members of the executive, members of the legislature. So that was a very real danger. And of course, there was this element of two eminent persons, which was just two famous, well-known, learned academicians or scholars or legal luminaries who would be included in this commission. So, of course, this law was itself a subject of much criticism, and eventually it got challenged in the Supreme Court of India. I think this is where I will now start bringing the discussion a little bit back to the basic structure point. So the Supreme Court of India heard a very long set of arguments about why this law was unconstitutional or constitutional. And I think one of the main issues with the way that, first of all, this case was argued, and I was a very small part of this litigation, but I was also supporting one of the lawyers who was supporting this litigation, one of the states of India that signed this amendment. And so our work was to justify the law in front of the court, because the state had said that, yes, this is a good way to select judges. Now, I think there are many elements to this. First of all, of course, there was the immediate reaction that this was just a reaction of the government to sort of try and reclaim that power, because the judges were being selected by judges. So they thought, okay, this is a perfect opportunity for us to now inject members of the government, of the executive, of the legislature, some people we have influence over, and we will essentially then sort of dilute the veto power of the Chief Justice of India. However, there were also many arguments in favor of the legislation, because it would hopefully lead to more diversity, and there was some research done why a commission was better. But at the end of it, what happened was that I think there was a lacking of doctrinal understanding when these issues were being argued in the Supreme Court. Many arguments were put forth, many issues of why the law is good were put forth, but ultimately the court decided it was unconstitutional, basically on the premise that it violated the basic structure of the Constitution. Now, like Siddharth has discussed, I think the problem with saying basic structure itself in India is that the judgment which led to the establishment was a very politically motivated judgment. During the judgment, and this is written in a very well-written book by a lawyer that Siddharth has worked with, Mr. Andhyarjuna, he actually says that even during the judgment, there was shifting of power within the court. There was talks of replacing people in the court. So the basic structure doctrine itself in India is very broad, and it's not very clear. I think this is one of the biggest dangers. So as a result of this, what happened when this constitutional challenge of the new appointment law was happening in the Supreme Court was that there was not enough depth in these discussions. It was basically the court took about 1,000 pages to basically say, okay, judicial independence is a part of basic structure. The primacy or the supremacy of the Chief Justice is a necessity for judicial independence. And then they drew the conclusion that therefore replacing the Chief Justice and his power with the commission would violate the basic structure. Now, my criticism on this is mostly based on the fact that I think the basic structure doctrine was first of all problematic and itself needed to be sorted out. And secondly, it was applied very wrongly in this case. There are many parts of the judgment which talk about the discussion of basic structure, but they lack a doctrinal depth. There was no engagement with the fact about where judicial independence fits in within the basic structure. There was also no discussion on judicial power and a clear discussion on separation of powers. In fact, there was a very disappointing part of the judgment where they talk about separation of powers, and in a very superficial way, even in court, because I was there and I remember that the Chief Justice of India at that time actually said something along the lines of, the members of the judiciary often have tea with politicians, and this would often lead to sort of mixing of the two organs of the state. And I think that itself was a very strong inclination that there was a complete refusal of engagement in a doctrinal and an academic way with the idea of basic structure and judicial independence, and where this would fit into the discussion of how to go about either incorporating or rejecting this new appointment system. I'm going to now move on to the criticism of this, not only this judgment, but how this impacted judicial independence. Now, as I've explained, they struck down this law. They said that it violates judicial independence, it violates basic structure. I agree theoretically, maybe on the understanding of the court, it did. However, as we see now, I don't know how many of us are familiar with the situation in India. I'm not entirely sure, and I think many scholars actually agree on this, whether keeping the old appointment system has actually strengthened or guaranteed judicial independence. I think it's something that has to be seen in a political context. So, for example, now, since the Modi government has come in power, there have been many discussions about how judges are now being transferred at the will of the political bodies. Judges are not sort of being able to take decisions independently. And actually, if you see some news reports from independent media houses as well, there are very clear indications, even in the high courts, which are a tier below the Supreme Court, that there are judges who give judgments which are not in favor of the government, and either they are transferred or suddenly work is suspended. And of course, there may be a few incidents, but I think the very fact that these incidents exist is something that should make us question the Indian idea of judicial independence in the first place. So I think basically what I'm trying to say is this idea of trying to preserve judicial independence by basic structure theory has essentially failed in India. And I think to blame for that is the way that basic structure theory is understood. I think it's not questioned enough. I think that there is no nuance to it. So, for example, now I move on a little bit to the comparative studies. After I spoke with Siddharth on this issue, actually, there's a very relevant paper by Rosalind Dixon and David Landau, who writes a lot about Colombia as well, as I understand, where they both talk about comparing India and Colombia when it comes to application of this doctrine. And something they said, which I really agree with, is that they say that the basic structure doctrine, of course, is not a complete solution to sort of aggressive or abusive constitutionalism, like Siddharth was saying. And in my case, the abusive constitutionalism is basically that the independence of the judiciary has essentially been eroded by the government, and there's a nexus, so that's a problem. But I think they said that the basic structure theory is only a partial solution. So this was interesting for me, because according to them, the other half of the solution would be transnational constitutionalism. And I think this is where I differ. I think the reason for this is because while I think the situation of Colombia, even the situation in many other jurisdictions that I read about, is very similar to India, I also think that in the Indian context, there are very specific set of circumstances which sort of divide the power between the judiciary and the government the way that it happens. We've seen that no matter what the government comes in power, the Supreme Court has a certain sort of reaction to legislation. It's very hesitant to strike down legislation, but at the same time, when it was confronted with a question about its own power, it struck the legislation down. Now, I feel that, of course, there is no perfect solution to this. It's about context. There are a lot of political issues involved. But I feel that on my reading of a lot of constitutional cases in India, I think we don't have a tiered or a nuanced approach to basic structure theory like I think we should. I mean, from the laws that Siddharth discussed, from the cases, I think the problem is that we always have to sort of tease out the elements of what the basic structure is. And because it's broad, the court is constantly trying to also expand it. And, you know, with every new constitutional case that comes, there's always a new way to take out something that is basic structure. But nowhere has basic structure been discussed in a legal doctrinal way. I think even in the Keshwanand Bharti case, it almost seemed like a philosophical discussion of what is basic, what is essential. And while that's very important, I think it's time that India re-examines this. And I'm sure there are many criticisms of Colombia, but for me, especially when I read the presidential re-election cases, what really struck me was that there was an engagement with what the basic structure is. It was not something taken for granted. And also in, you know, as recently as in the last decade, I think in India, ever since 1973, we've been working with the same definition of basic structure in so many different political contexts, whether it's about reservations in our government jobs, whether it's about judicial appointments, whether it's about sort of gender equality. And I think the danger is that while rights adjudication is evolving, the idea of basic structure has sort of stayed stuck in that definition that we had in 1973. And India's constitution is very dynamic. So I really wonder, as a scholar, is this the fault of the Supreme Court? Is this because the Supreme Court, as I was in a previous discussion with a colleague of mine, she said that, is it because the Supreme Court is probably always deferential to the government? And where does this problem lie? And I think these are all very important questions that we need to ask in India, which unfortunately are not really engaged with as much. I think it's very good that a lot of constitutional law scholars are now engaging with this, but I think there are many gaps in the literature. And I actually feel that we Indian scholars can learn a lot from Colombia, because I really just read the summary of the presidential re-election cases. And for me, the engagement of the court with certain things, I think that was something that I have never really seen in terms of this particular doctrine. So I just want to conclude by saying that I think, since it's my subject of study, I think the idea of this basic structure doctrine has unfortunately completely wrecked with the idea of judicial independence in India. And in theory, the court thinks it is completely separate from the government, but there is an undeniable influence. And whether it's context or doctrinal, I think all these things, they need to be discussed. There needs to be a conversation about this. So I think I'll close here, if that's all right.
Yes, thank you. Thank you very much, Meda and Siddhartha. We learn a lot of all of things, not only of the basic structure doctrine, but all things related with the independence of justice. And the last part of your presentation related with the judge's case will be also fantastic for us in comparative perspective, because also we have some problems related with that in Colombia. And we have also a decision in 2016 related also with the independence of the judicial branch, and also some of the constitutional amendments related with the peace agreement, and special jurisdiction of peace also bring that principle as a basic or a structural principle of the Constitution, the independence of the judicial branch. So I'm going to translate a little bit the basic ideas of your presentation. I have here something that maybe you can see it in Spanish. Voy a hacer una pequeña traducción, no una traducción fiel, digamos, exacta, pero sí con las ideas que nos trajeron aquí tanto Siddhartha como a mí, como Meda. Entonces, en la primera parte, pues Siddhartha nos hizo toda podríamos decir, el recuento de la doctrina básica de la Constitución en India, la Basic Structure Doctrine. No nos contó el caso. He didn't talk about the German professor, but we are going to ask him about that history. No nos contó sobre la historia del profesor alemán que fue a la Corte Suprema de Justicia en India y trajo la idea, sobre todo sobre la base de la doctrina de Carl Schmitt, pero ahorita le hacemos la pregunta. pero sí nos explicó que, bueno, desde 1950 y pico se empieza a hacer unas primeras aproximaciones sobre la posibilidad de declarar inconstitucional reformas inconstitucionales, pero no se logró. Y solamente fue como en el caso de Ghulam Nath, State of Punjab, que es 1967, en donde se empieza a tener en cuenta la idea de la inconstitucionalidad de las reformas inconstitucionales. En ese caso, pues se hablaba de los derechos fundamentales como la estructura básica, ¿no? Nos trajo a colación el artículo 13 de la Constitución, que dice que no se puede ir, digamos, ninguna ley ir en contra de los derechos fundamentales, y es un poco la discusión sobre si la Constitución es una ley o no. Nos contó de que, bueno, finalmente hubo un parlamento interino, pero después ya se llegó en el caso que Sanabanda Bharati versus Kerala del 73 ya a hablar de la doctrina básica de la Constitución, de Basic Structure Doctrine, y se amplió no solamente a los derechos fundamentales, sino a esta idea que también nos contaba Meda, que es muy amplia, que es los elementos básicos de la Constitución. En el 74 nos cuenta Siddhartha la enmienda 39 y 42, en el caso Minerva Mills y en el caso Indira Nehru Gandhi. Fue muy polémico porque se trataba ya de unas elecciones, ¿no? Y en este caso parece que Indira Gandhi, que era la hija de Nehru, había hecho algunas prácticas de corrupción para obtener el triunfo, y hicieron reformas a la Constitución en la India para tratar de evitar el juicio político, digamos, a la primer ministro. Y allá se discutió pues otros principios, ¿no? Que tenían que ver con la democracia y con la idea pues de la separación de poderes. Y es interesante porque nos dice y es si el Parlamento podría ser de juez, porque al hacer una reforma constitucional en donde se impedía hacer un juicio a la presidenta, a la primer ministro, pues lo que estaba haciendo el Parlamento era haciendo como juez. Entonces allí se discutió también el principio de independencia judicial eh, que pues nos está hablando aquí también Meda. Y allí se empieza a dar toda una polémica, ¿no? Con relación a las elecciones y el rol del presidente y el conflicto con la Corte Suprema de Justicia. Siddhartha no nos habló de los últimos dos casos, que es Waman Rao, ya nos contará, y Ashoka Kumar, pero pues al final fue crítico también sobre la doctrina básica de la Constitución. Los dos han sido diferentes con Colombia, un poco generosos en que han hecho algunos, y Meda, digamos, acercado al derecho constitucional colombiano, con algunas lecturas que le pasó Siddhartha, especialmente Rosalind Dixon y David Landau, del constitucionalismo abusivo, que tienen una perspectiva comparada, y en el caso de la reelección del presidente Uribe, digamos que ella, tanto Meda como Siddhartha dicen que es una buena decisión, en donde pues se empieza, digamos, a dar una aproximación más doctrinal y teórica sobre qué es lo básico, qué es lo esencial, qué es lo que un poco echa de menos Meda. Meda, por su parte, bueno, al final digamos que Siddhartha utiliza la idea del constitucionalismo abusivo también para, digamos, en este caso, pues tener en cuenta que el poder de la Suprema Corte podría llegar a ser muy grande también en utilizar la doctrina básica de la Constitución. Meda nos dice, bueno, que ella está estudiando todo lo que se refiere a lo que es el nombramiento de jueces, ¿no? Esto es un caso y la responsabilidad de los jueces, que es un tema, digamos, de doctorado, y allí lo relaciona con el tema de la estructura básica de la Constitución. En el 2014 se hace una ley que empieza, digamos, a cambiar la nominación de los jueces a través de una comisión conformada, y esto es interesante, digamos, por el presidente de la Corte, por unos jueces, digamos, ya senior judges, podríamos decir, unos jueces veteranos también, o jubilados, pero también estaba en esa comisión el ministro de Justicia y algunos miembros eminentes. Entonces esto se dio porque, digamos, había un conflicto sobre quién debería nominar a los jueces federales en la India, tanto, digamos, los jueces de tribunal, podríamos ser aquí, pero en un estado federal, pues los hacía la Corte Suprema de Justicia, su presidente, pero podríamos decir que con el consentimiento del presidente. Entonces esto empezó porque tenía que hacerse una consulta. Esto empezó a crear una serie de problemas porque pues dijeron como así que el presidente, es decir, esa consulta es obligatoria o no, y si el presidente podría, digamos, rechazar alguno de los nombramientos que él se haya hecho por este sistema un poco de cooptación. Entonces se decidió crear esta comisión, pero fíjense ustedes que lógicamente aquí también se empezó a criticar, porque así como así que una comisión en donde también hace parte el ministro de Justicia, pues eso puede llegar a tener riesgos, sobre todo en esta idea de cooptar las cortes y los jueces, que han sido bastante independientes en la India, y entonces se declaró inconstitucional esa ley de donde se crea esta comisión, y se utilizó el principio de independencia judicial como un principio básico de la Constitución de la India para declarar inconstitucional esa ley que creó la comisión. Entonces, pues allí Meda, digamos, cierra su presentación diciendo que, pues que esto le causa, digamos, en estas sentencias que parecen ser mucho más largas que las colombianas, nos dicen que son 2000 páginas, tanto la del caso Indira Gandhi como la última de los jueces. Pues se dicen muchas cosas, pero finalmente no se ha logrado en estas decisiones lograr identificar qué significa por elementos básicos de la Constitución, qué es lo básico, qué es lo esencial. Y me da un poco con la lectura que está haciendo ahora las primeras aproximaciones al caso colombiano, pues ella dice que en cambio en Colombia sí hay como una aproximación más concreta de qué es lo básico y lo estructural, especialmente en la decisión del 2000, digamos del 2010, 241, C241, sobre reelección presidencial. Pero yo creo que pues nosotros también tenemos muchos de los problemas de indeterminación que tiene la India sobre qué es lo estructural, qué es lo básico de la Constitución, en nuestra doctrina de la sustitución de la Constitución. Entonces, más o menos lo que dijeron los profesores, vamos, so we are going now to open for questions. I don't know if someone from the public want to make a question. Even in Spanish, we can translate it. Here is Sara, who is going to help us with the translation. Viene Juan, va a hablar. Si quiere Juan, lo subimos aquí para que lo vean. Y también está Jonathan. Entonces, mientras llegan, we have two persons who are going to make some questions. So we are going to have both of them here in the panel. So here is Juan.
Yes. Well, first of all, thank you very much. I know that you are probably at night in India. I don't know what is the time schedule there. So thank you very much for being with us. I would like to ask something. I'm working on corruption, on electoral processes and electoral finance. And I'm really interested in the point that you make about this Indira Gandhi versus Rak Narayan of 1975 that involves some change in the rules about the political process to avoid or to change the rule for political corruption. And since I'm not familiar with that, I would like to know a little bit more. And also if maybe through Gonzalo, or you can send me some information so I can study more the case, because obviously for us in our democracies, corruption is a big challenge. and my focus is corruption in electoral process. So if you can elaborate a little bit more about what happened at that time and how it was related to the Constitution itself. Thank you.
Should I answer, Bino? You would like to answer?
Yeah, it's okay. You can answer.
So this was very interesting. This is a very interesting question because what happened in 1975, Indira Gandhi went for an election and she won it. And that election was declared to be invalid by the court in a state high court, which said that because she engaged into electoral practices, malpractices, her election is declared to be null and void and invalid on the ground because she violated the provisions or the sections of a particular law which declared that if you engage into certain practices you are barred and your election will be declared unconstitutional. Now what she did after that is also this whole scenario will take another 2 hours to discuss because this whole scenario was political, because it was believed that the judge who passed the judgment against Indira Gandhi was someone who was very close to the opposition. And when her election was declared to be unconstitutional and invalid, she came to the Supreme Court to challenge it. And the Supreme Court gave her a very limited power that she would still continue to be the Prime Minister, but she will not have the right to cast vote in any of the proceedings which are taking place in the Parliament. Now, what she did is something that is considered to be a blot on Indian democracy, because the moment she got that order from the Supreme Court, she declared the emergency in India. Because after that, she took the control of the entire affairs, and then she, like Medha talked about, the transfer of the judges who were against the government, also incarceration or detention of the people who were against the government. So all these things happened. Now, what she did when the emergency was lifted and her election case was to be heard by the court, she introduced this amendment. And according to this amendment, the law according to which her election was declared unconstitutional or invalid, that law was removed and that law was put under the ninth schedule. And the court said that whatever was pending or whatever election petitions were pending against her were declared to be null and void, and the parliament, and not the court, but parliament will now enact a court to hear the petition which was pending against her. So in a way, what the parliament did was to remove the power of the high court or the constitutional court to judicially review what was allowed to it by the constitution. And they said something which will be a creation of the parliament would decide on the validity of the election. Now that was very problematic from a democratic point of view, because it was considered that she is now becoming a judge in her own case, and then she is also being allowed to continue in the office despite the word declaration of invalidity for her election. So all these things led to culmination. But interestingly, I'll tell you, when the matter come to the Supreme Court declared her election to be valid because they upheld, they disallowed the changes in the constitution, but they allowed the changes which were made to the law. So, I mean, the constitutional amendment was declared to be unconstitutional, but the provisions of the law under which her election were declared invalid, those were allowed by the court. So in a way, she won, but the amendment was lost. Just like the Malbury case where judicial review was preserved, but the power was lost. So, I mean, just to briefly discuss this bit, but I'll send you some relevant document that can be of interest to you.
Please.
So what happened.
I'm going to put my email on the chat. If you can take it and send me some information, I'm really interested in that case. Thank you very much.
Thank you.
Yeah, I just wanted to add a small comment. In addition to the constitutional law, I think something which might be very interesting for any sort of comparative law scholar is if you read the Representation of People Act in India, and particularly also the issue of criminalization of politics, because election law is one issue, but there have also been a lot of judgments by the Supreme Court talking about how to deal with it when a person who is sitting to be a member of the parliament has a criminal record. And unfortunately, this is quite common in India. I mean, like you said, that you are also dealing with election law and how corruption is a big problem in your jurisdiction, but in India as well, this is something that is a very big problem. And I don't think this is somewhere where the law has found a solution yet. It has a lot of sociological reasons, but this is also a very important issue to understand why it is so normal to have people with criminal backgrounds in politics. We can of course say that it's because of power and society, but I think there is a way that the law is lacking. So that's also maybe something important to think about.
Yes, and I think there is a Supreme Court case called Manoj Narula which discussed this point. So I can also share that case, because I think they said that until you are convicted and everything, you can continue to be the member. So if there are cases against you, that's fine. But I'll share that.
I appreciate your thoughts, and if you can send me some information, it would really help me. Thank you.
Thank you very much. So one question for related with that topic. So Indira Gandhi remained in power after the decision.
Yes. Like they allowed the amendment in the act, which is the ordinary legislative piece, but they disallowed the constitutional amendment. So she won in a way. Her election was upheld, but the constitutional amendment, like Mehta rightly pointed out, that it has always been about the philosophical basis like democracy and judicial independence, but on the ground the court have always ruled against the petitioners. Like if you take all these cases where the court have discussed the basic structure and the judicial independence, barring the judicial judges cases, every time the petitioners who have come to the court alleging violation of basic structure, they have been their rights have been violated, and the court did not use the basic structure to uphold the rights, but to do something philosophical, like Mehta rightly pointed out. So the court have never shown its teeth to bite, but it always like that.
Okay, thank you very much.
And also one thing that we did not discuss, which like in India, not only the constitutional amendments, but even ordinary law, which is passed by the parliament in its legislative capacity, can also be challenged on the ground of violation of basic structure.
Okay, yeah, we understood that. Bueno, muy bien, entonces es un extraño. Digamos, finalmente Indira Gandhi, el caso fue declarado inconstitucional la reforma, pero no la ley, y con lo cual ella permaneció en su puesto. Su puesto. Pero es bueno. Vamos a ver con la segunda pregunta, Jonathan.
Sí, señor. ¿Me escuchan?
Perfecto, sí.
Okay. So when talking about the discussion between the Supreme Court and the Parliament about the limits of the constitutional reforms, Mr. Siddharth told us that the Parliament said that except limitation to its powers would mean a violation of its right to carry out constitutional amendments. So I would like to ask if that's the way that the Parliament see its function as a right.
Would you like to answer this question?
I can just briefly I might not answer your question exactly, but I think this is something which is very relevant to what I'm studying right now, because I talk a lot about judicial independence and accountability in my thesis. I think the question is not more of whether the parliament sees it as a right. I think it sort of goes back. I mean, of course, I understand that's the inquiry, but I think for that there's a larger discussion that needs to be had in the context of separation of powers and where lawmaking power lies in India. So, for example, sort of did not really talk about the UK, but in the UK there's very clear parliamentary sovereignty, and in India it's I think I'm going back to the basic structure problem. I think in India the problem is that we are not able to clarify where the power lies, because it's always been a tussle of power, and it depends on political situations. So the parliament makes a law, like the amendment for judges appointments, it was passed by a 99% majority. I think literally one person in the parliament voted against the law. And you would assume in a democracy which is so diverse like India, which has representative elections, that there is a law which is passed by more than a clear majority, almost 100% majority, and yet the Supreme Court has the power to declare that law unconstitutional. So I would think from this point of view that it's the Supreme Court who decides what the law is or not. And yet that's not really the case. But I think that's just my 2 cents. I think Siddharth can also take over, maybe give a more legal answer for this.
No, like the only thing that I would like to add is that if you look at the definition in the amendment power of the parliament itself, it declares the parliament to be the constituent authority. And like I discussed in the first case of the Shankari Prasad case, where the court have said that when the parliament makes the law, which is an amendment to the constitution, it does so in the capacity of itself being the constituent authority. So now when that was the law of the land for many, many years, the parliament looked at it that there is no limitation in the constitution. I mean, even the Golaknath case was a case which was of a political nature, because the judge who passed that judgment against the government and the claim of the government that there is no limitation on the power and he declared that there are limitations and fundamental right cannot be challenged or cannot be violated. The same judge resigned and was fighting an election to become the president of India, because the opposition parties have asked him or supported his candidature in the parliament to stand as the president. So the thing was that the government of the day then and the opposition who was trying to use judiciary, if you look at it from that perspective, was in a kind of a tussle. And parliament thought that for all these years, when the court have given it right to make laws, and the laws which deals with the amendment, that was the right of the right and the power of the prime parliament, and that right was taken by something which was never found in the constitution, but just made out of philosophical basis, but no legal basis. So that has always been the question against basic structure theory, because I think nowhere the parliament is defined as the constituent authority. Even in Colombia, in other jurisdictions, if we read the cases, they define it as a Congress or the parliament, but they never are so expressive in the fact that parliament which exercises its power as the constituent authority. So it actually gives the assurance to the parliament that it is a constituent authority. But despite that, the court have ruled against it. And I think parliament never took it in a way that court can dictate it to do what it wants to do, because courts are something which is creation of the constitution and not above the constitution. And here in these cases, the constitutional court acted beyond the constitution. So that is my take on this.
Okay, thank you very much.
Thank you.
Bueno, Siddhartha nos contó un poco. Nuevamente, algo que no se nos olvidaba era como que el artículo 368 de la India establece que el Congreso pues puede ser un poder constituyente, constituent power, dice, pero la interpretación de la Corte Suprema pues fue que no podía ser un poder constituyente, sino un poder constituido, y ahí fue como realmente donde empezó a dar otra doctrina con relación a lo que podría ser ese artículo. Vamos a hacer otra pregunta que está aquí. We are going to do another question that is in the chat. That is Alexander Andrade. Alexander, hablar de una indeterminación de la estructura básica de la Constitución no genera un problema en el sentido de la interpretación. So he has, talking about the indetermination of the basic structure of the Constitution, generates a problem in the way of interpretation. It's not a problematic issue related with interpretation, that is indeterminacy of the what is basic structure. We are in the mercy of the now of the judges, that in each case they interpret what is basic structure means.
Should I start?
Or yes, Meda.
Okay. I think, yes, of course, that's a very real problem. I'm often confronted by it in my work. So if I understand the question correctly, it's basically whether if we leave the basic structure to be decided by the judges, it'll be dangerous for us, that we'll be at the mercy. If you ask me honestly, I think currently that is what is already happening. But there's sort of, I think, almost some dichotomy there. So the basic structure that at least exists in India, it is what the judiciary has laid down. It is, but that is what I'm saying. There are many layers of complications. First, it's laid down by the judiciary in a very specific political background. But at the same time, it is something the judiciary by itself created, therefore exerting its power in that aspect. I don't think the problem for India right now is who is describing it as much as what it means. And I think, without sounding too idealistic, I don't think it is something that can be decided by one organ in vacuum. I think the idea of basic structure is something that's very influenced by political doctrine, by the social cultural framework of a country. And of course, these are all very theoretical issues, but I think like I mentioned before, the problem is that we have a core basic structure doctrine which is very broad, which has not evolved with the time. So, at least for me, I think the source of the doctrine is not as much a question as is the content of it. But of course, that's just my opinion. I think it's because I also study powers between state organs that I have a slightly institutional answer to this question. But I think maybe if Siddharth could provide another perspective, if he has something to add.
I would just like to say that because I was working with a lawyer who used to appear in the Keshanandan Bharati case, and he has also written a book about it. So in my discussions with him, because he was attending the cases every day in the court when it was being argued, his point was that if you read this judgment runs into more than 1,000 pages, and his point as a academician, as a legal scholar, was only on the point that do we have a ratio, do we have a reason on which we can say that this is why we have basic structure. To just give you an outlook, because he discusses this in his book, when this matter started, there were 13 judges on the bench. 6 judges wanted to say there is a limitation on the power. 6 judges wanted to say there was no limitation on the power, and only one judge who said and talked about basic structure. So basic structure theory, as we discuss it in today's literature, it only came into existence because there was one judge who thought like that, and 6 judges who were favoring limitation on the amendment power just said, okay, we agree with him. So there was, I mean, if you look at it from that point, if you look at it from an academician point of view as well, like judges never wanted to resolve the issue, but they wanted to contain the executive and the parliament for whatever reasons that they might have had. So there was no legal sanctity that can be attached to the doctrine, because even if you read these pages, if you read those judges, if you read 6 verdicts, you will find no mention of limiting in a way that you can amend anything in the constitution but the basic structure. They say you cannot amend fundamental rights, which was the basic question before the court. So to say that judges have got this power to themselves is very correct, because after those cases, there were so many cases which have been filed where the courts are also ill-equipped in constitutional law. I think my personal take also has been that when I read the constitutional cases in India, because this judgment was all philosophical in the sense that there was no legal basis to it, judges have also in the present time followed the same approach. They don't look at what is the yardstick to measure the essential feature of the constitution, but they just feel that if on the face of it something appears to be violative of democracy, then they will do it on the ground that it may be abused, but they forget that only the abuse of the process or only the abuse of the amendment procedure cannot be a ground to declare a law to be unconstitutional. You need to design a particular mechanism to decide what is and what is not unconstitutional when it comes to the basic elements of the constitution. So in my view, that it has become too judges centric, and the problem is that tomorrow if the judges who are similar minded come on the bench and they share the same podium, then they may come up with a theory which is completely against the essential elements or the basics of the theory, like we saw in the Honduras case, where the 4 judges declared the original provisions of the constitution to be unconstitutional after the packing of the court. So because there is no yardstick to measure basic structure, it is susceptible to misuse by the court. I feel that, and that is very problematic.
Bueno, muchas gracias. I'm going to do a little translation for Alex. So, ellos dijeron que, pues sí, que este es un gran problema, que los jueces sean los que determinen el último cuáles van a ser los elementos de la estructura básica. De eso Meda ya dice que este es un problema que está pasando ahora y que se puede tornar, digamos, puede llegar a que sean elementos políticos, porque realmente vuelve a repetir, digamos, como qué significa elementos básicos de la Constitución o estructura básica. O sea, que ella está de acuerdo con la idea, pero no está de acuerdo con la idea de que no se le ha dado contenido a esos elementos. No se ha hecho ninguna aproximación teórica, doctrinal, sobre qué y cuáles de pronto podrían ser los elementos básicos de la Constitución, con lo cual pues está a merced, podríamos decir, de los jueces en la determinación de esos elementos. Y Siddhartha vuelve y nos dice, pues sí, eso es un problema, es decir, una vez el primer caso que estaba relacionado con los derechos fundamentales, pero después se abrió en que Sanabanda a los elementos básicos de la Constitución, pues puede dar lugar a que no haya un límite, ¿no? A la labor de los jueces en determinar qué se entienda por elemento básico de la Constitución, y que podría pasar, nos recuerda el caso de Honduras, que en una sentencia pues estableció que la reelección del presidente, ellos tenían una cláusula pétrea que impedía la reelección del presidente, recuerdan con el caso de Zelaya, pero después llegó otro gobierno y hizo esa modificación y la Corte Constitucional hondureña estableció que era constitucional a pesar de que existía la cláusula pétrea por el principio básico de la reelección del presidente, que ahorita hay un caso o una consulta que hizo Colombia a la Corte Interamericana sobre si la reelección se puede entender como un principio básico de las constituciones, y la Corte Interamericana estableció que no. Entonces sí queda como este problema, ¿no? Un problema donde pues finalmente la última palabra lo podrían tener los jueces, y esto puede generar, digamos, algunos elementos problemáticos, incluso abuso del constitucionalismo. No sé si tengan otra pregunta. So I want to ask one question. One is related, or two questions. One is related that history related with the German professor who came to the Indian Supreme Court, and then he did a conference related with the Schmidt theory, Carl Schmidt, no, related with the difference between constituent power and the power of amendment, and then it is related with the first decision. And the second question, I wonder how you challenge a constitutional amendment in India. How you do to sue a constitutional amendment in India? Every person can do it, every citizen, or only special, I don't know, members of the parliament? Because here in Colombia we have the public action, that it means that the citizens could challenge a constitutional amendment and also a law, and every citizen can do it. I don't know what is the process in India. So that is the two questions. So le quise preguntar cómo hay una historia sobre que hubo un profesor alemán que llegó a la Corte Suprema de la India y dio una conferencia sobre la diferenciación que tiene Carl Schmitt entre poder constituyente y poder de reforma, y este profesor, I don't know the name of the professor, you can't remember, but fue el que inspiró la tesis de la doctrina básica de la Constitución. Querría saber si eso es verdad y cómo fue que se dio esa relación. Y luego está una pregunta, es más de curiosidad, y es cómo se demandan las reformas constitucionales en India, porque acá en Colombia, pues saben ustedes que existe la acción pública y cualquier ciudadano lo puede hacer.
So it was Professor Conrad who had come to deliver his lecture in one of the Indian universities. And his point, he was basically giving a discussion on the eternity clauses under the German constitutional law. So he had discussed that every constitution contains implicit limitations that the parliament cannot exceed when it comes to the amendment that one makes to constitution. So to answer that question, that it was, I mean, if it would have been Carl Schmitt, we would have gone the other way. But it was Professor Conrad, who came up with this theory, and that was vehemently argued in the Golaknath case, because the premise of the Golaknath case was that there are implied limitation, and Article 13 that says no law can be made that takes away fundamental right is itself an implicit limitation on the constitutional amendment. And
yes, and Mela, could you please answer
So I'll just engage with that. So I think if I understood correctly, wanted to know how you sue a constitutional amendment or how you sort of deal with it. I mean, it's interesting. I think this again opens up this big question of power. But just to cut a long story short, there is an article in the Constitution, Article 32, which allows you to file a writ petition in the Supreme Court. So under this, you can challenge when the fundamental rights have been violated. And this is how in India, the concept of public interest litigation started. So you talked about public litigation in Colombia, which I'm assuming is that any person can file litigation in the constitutional court when a certain right has been violated. I could go to India and say that the right of a particular group of people is being violated because they do not have housing, they do not have food, and I will have stand on that. But what is interesting is this is a whole new area, I mean, a whole different area of jurisprudence, because the idea of locus standi, I don't know if this is the same thing you call in Colombia, is sort of very broad in India. So on the one hand, I can go and sort of petition to the Supreme Court that my fundamental right is being violated or the fundamental right of the public is being violated. But if I do not succeed under that, I can also go under this very, very broad power that the Indian Supreme Court has. It's under Article 136. So it has nothing to do with fundamental rights in particular, but it's sort of this provision dealing with a special leave petition where you can file an appeal or you can file sort of a review, or it's basically just a very broad power. There are very particular powers in the Constitution for review and appeal, but 136, this article is sort of this, one size fits all thing, with which anyone can approach a court. But I think I would say that it's actually a very sort of I couldn't give you a direct answer about how one could challenge the constitutional amendments, because on the one hand it's quite easy, because you can show that amendment directly or indirectly violates a right of the public. You can go as a person and say that you can stretch it as much as you want. I think lawyers are very good at doing that. But on the other hand, you should also know that the Supreme Court of India has a very unclear set of standards on how it admits cases. So tomorrow, I could have gone as a citizen of the country and said, this law for judicial appointments sort of destroys the independence of the judiciary. And as a citizen, I'm affected by it, because this means that justice will be biased, it will be political. Probably the Supreme Court will say, no, you are not affected by this. But if there's a very liberal judge sitting, he could just say, yes, I understand why you are challenging this, and please come and, we will sort of admit your petition, please argue. And actually, in the case where the constitutional amendment of the judges' appointment system was challenged, I don't know, there were hundreds of petitioners in the case. It was not just the states, but it was democratic organizations who were saying, oh, we don't want this change in the constitution. Or there were organizations who were saying, yes, this is a good change. It will lead to more transparency in the judiciary. So, the concept of standing is very broad, but I think the balancing factor is that the Supreme Court of India has very, very broad discretion. So largely it depends on the judge sitting on the bench. And in fact, I don't know how it is in Colombia, but in India, public litigation is also very criticized, because they say that it's a good thing, it's very good for the social rights of the country, but sometimes it's misused. And if you have a judge who's willing to be complicit in that, it can also be misused by the government or some actor of the state indirectly. So yeah, if that answers your question.
Yes, it answered my question. Thank you very much. Voy a traducir, I'm going to translate a little bit your answer. So, Siddhartha dijo que sí, que hay un profesor que es Dieter Green. Esto ya es una historia que más o menos está consolidada. Acá, por ejemplo, en el libro de Yanib Rosnay, en la página 43, nos habla sobre Dietrich Green, un profesor alemán, que en febrero del 65 fue a dar una conferencia en la Facultad de Derecho Banaras Hindu University, y que hablaba sobre sí, la idea nos dice Siddhartha que sobre el artículo 79.3 y las cláusulas de eternidad en Alemania, ¿no? Y allí hay alguna aproximación sobre lo que pueden ser los límites implícitos de la Constitución. Al que le gusta investigar sobre el tema, entonces allá podría estar uno de los orígenes. Pero también Siddhartha nos decía que desde el 50 se venía haciendo la aproximación. Ya sobre la segunda pregunta que les hice fue cómo se podría demandar una reforma constitucional, y Medan me dice, mire, pues es como usted puede demandar a través del artículo, bueno, de la Constitución 136, sobre que le afecta un derecho fundamental, y si le afecta un derecho fundamental usted puede llegar a incluso demandar reformas constitucionales. Pero ahí también nos hace la crítica. Esto ha dado lugar a que en algunos casos se acepte, otra cosa no se acepte, que son, digamos, las demandas, porque es muy discrecional, ¿no?, sobre esto. Pero una vez que haya sido resuelto por la Corte, pues esto hace como el stare decisis, y esto un caso puede dar lugar a que pues los otros casos también. So I want to ask you related with this kind of procedure about the suing, because it is related with the fundamental rights, and the first decision was related also with fundamental rights. Do you think that still, because of the procedure, the basic structure doctrine could be related only with fundamental rights or not?
Just very briefly, this is something that actually came to my mind when I was preparing for this talk. So most of the discussion that the basic structure doctrine revolves around is whether a certain right has been violated under the Constitution. And then it comes up about, is this right part of the basic structure? Has this amendment led to a significant alteration of the right? But I think this is where sort of what I talked about came in, the decision about rejecting the new system of appointments. I don't think that was related to a fundamental right. It was more related to the separation of powers, and that itself is a part of basic structure according to, Keshwanand Bharati, because it's such a broad definition. And so in that case, I think it's a very relevant question, because I think this is exactly where the core of a lot of Indian constitutional theory questions lie. We talk about basic structure, we talk about rights, we talk about sort of rights, Bill of Rights, rights violations, huge topic. But I think also we have to see basic structure in the context of different state organs, because I think that basic structure has, as we have seen, it has the power to sort of alter the relationship and sort of the role of different organs in a country. I mean, what happens in a democracy like India when there are riots, there are a lot of religious tensions, communal tensions, then what is the place of the court? Right now, the court is essentially silent. There's a lot of political tension in India, but the Supreme Court of India is unable to do much because I feel its independence is compromised. So I think that's where basic structure goes much beyond a discussion on rights. I think it goes at the very foundation of sort of the constitutional structure of a society itself, if that somewhat answers your question.
Sí, muchas gracias. Entonces, Meda me respondió que pues eso es una pregunta que se había hecho ella preparando esta presentación, pero ella cree que va más allá de los derechos fundamentales. Recuerden que Sanabanda dijo que no eran solo derechos fundamentales, porque en el último caso de la nominación de jueces, pues ella cree que es el principio de separación de poderes, y ese es un principio que va más allá de los derechos fundamentales. Hay una pregunta de Darío Dangón. Darío, ¿quieres hacerla directamente o la leemos? Si lo podemos subir. So Darío is asking the both panelists, thank you very much for in advance. Do you find a relation between a doctrine like the basic structure of the Constitution and its development in societies that are very diverse, as crossed by several cultural and social conflicts, and in which the democratic values have no settled solidity in the culture? So aquí está Darío. Here is Darío.
Siddharth, you want to take this one?
Sure.
Yeah.
Okay.
Darío, ¿quieres decir algo?
Si es posible.
Sí. So
Sí.
Darío is going to talk about a little bit his question.
Yeah, thank you very much, Professor Gonzalo. No, thank you very much, Meda and Siddharth. I found this very enriching and very interesting. For so long, I have been looking forward to know something more about the constitutionalism in India. I'm very interested. I have this idea. I have the idea that the doctrines like the basic structure of the Constitution or the substantial elements of the constitutions have some relation with the fact that the democratic values, we could say that the values of the liberal democracy haven't settled solidly in the political culture. And I find some relation between that fact and the development of this kind of doctrines. For example, we can take the case of Germany. I think it is not casual that Germany developed the idea of what has been called the constitutional fundamentalism, the idea that the fundamental rights cannot be touched, not even by the people, or in our countries, in Colombia or in India, maybe in South Africa, the idea of that there is some substantial elements of the Constitution related with the key elements of democracy or key principles of the rule of law that cannot be touched, not even by the people, not even by the political processes of constitutional reform. And at the end, the idea is that maybe in democracy, in societies like ours, culturally really diverse and crossed by several conflicts of every kind, and where the democratic culture haven't been settled, maybe doctrines like the basic structure of the Constitution help in certain way to impose the democratic values over the culture, over the society. What do you think about it? Thank you very much in advance.
No, I think that is absolutely the right way to look at it also, because like, as we were mentioning about the cases that took place in India, though you can say that there was no philosophical foundations for the theory, but it was only reactionary to what the government was doing. I mean, Look what Indira Gandhi did. Indira Gandhi said that the invalidation of my election is and she invalidated her election, and she allowed herself to continue as the prime minister of the nation, despite that her election was declared to be invalid. Now, whatever may be the grounds be, but there is a system that you believe in, like you believe that there are courts, and you believe that courts are there for a purpose. Now, if you start questioning the functioning of the court, then you as a government may say that the courts are not functioning, but all the people would think alike, and they would start looking at the institutions as something which are corrupt. But if Indira Gandhi would have stepped down and did and came and got herself re-elected, then that would have been democratic. So I think the idea to preserve democracy and the idea to protect these values from erosion is to let the continuation of a nation. For example, if we start questioning every value, if we start saying that we don't want to be a democracy, let's become a Hindu nation or Islamic nation, or we become a particular type, then we must feel that if we are five people in a room and there are two minority and five people who are, or three people who are in majority, then there would be a situation where two might not feel safe and three would be the powerful. So that would decay the system, and that would lead to a decimation of a nation which is built on certain foundation or founding principles. Whenever a constitution came into existence, I mean, look at the French Revolution. When French Revolution came into being, there was three principles that they believe in: equality, liberty, and fraternity, and it continues till today. But there was a reign of terror. There were principles, there was violation of all these three principles that they believe in. But until today, they believe in that idea and they still pursue it, because that is a way where you can be woven as a nation. And these are the values that if if you go to any edge, if you go to any extent, you cannot cross these limits, so that the nation as it was formed and as it exists is protected from decimation. Otherwise, there will not be any rule of, when we talk about rule of law, the rule of law itself means that everybody should be treated equally, and everybody should be uh, is not above every, no one is above law. So I think these ideals are very important for the preservation of the nation, for which the constitutional founders come and declare that constitution will govern the state. So I think it has a very philosophical foundation, but these are also important, like religion, they talk about morals and everything. And I think constitution, in my opinion, work like a religion. And it does not include any particular religion, but it counts every citizen of the nation as someone who would follow that particular document, which should govern the behavior of the people. And I think that is very important for constitutions. I think Medha would like to add something to
Yeah,
it.
I just wanted to add something. Firstly, thank you so much for your question. I think this is a very, very important thing. And in fact, Siddharth and I have discussed this even outside the context of sort of this conference. I think for me, this is important because, and I also think that it's not something that you can particularly put pressure on any one institution for, because in India, for example, we talk about rights, but you also have to realize, because it's such a diverse society, different rights have different significance for different people. I mean, for me, I am a woman, so maybe I will talk about feminism, gender equality, but there will be a woman who lives in a village in India who doesn't have access to food and water. So her idea, or what the government or the courts owe to her, is very different from what I expect from them. So I think in that sense, it's very difficult in a diverse society. And I think we should also be careful to sort of, even glorify Western liberal democracies, because doctrinally I agree. Of course, a country like Germany, I mean, I've lived here for 3 years now, and I am dealing with a bit of German law for my thesis. So yes, on a doctrinal basis, they have very deep rooted rights. But I think there are still problems, because when any society evolves and any society becomes diverse, I think there are more and more questions that will rise. Now, for example, we talk about, I mean, this is a controversial example, but I'll just say this very directly. We talk about how sort of in Western European society, rights are very sort of entrenched, they are set in stone. There are some basic rights which cannot be taken away, but there's a huge Muslim population in Europe, and there's such a controversy about wearing the headscarf, and in this context, I mean, as an individual, I'm not particularly religious, but I would say it's the basic right of a person to practice their religion. But there is an equal and opposing argument where, in context of the society they live in, they are not allowed to do a particular thing. And I think this is where we also have to be careful to say, okay, this Western liberal democracy has everything, sort of the rights written down, and they are very clear about it. But I think there's also a danger in that, because then when you write something down in such a concrete way, it also gives the state and the courts an opportunity to impose those boundaries on people who might be new to that society, who might be different. So I think that's also something important which we need to think about, just maybe at a higher level. Of course, I think young democracies have many other things to deal with, but I think especially living in German society, for me, this was a very significant issue of constitutional law that I learned about in the last 3 years. So, yeah.
Thank you very much. Darío, ¿querrías traducir tu pregunta y respuestas brevemente?
Bueno, muchas gracias. Bueno, la pregunta básicamente estaba orientada a, que es una idea que tengo yo, en la que se relaciona, digamos, el hecho de que del desarrollo de este tipo de doctrinas como la de la sustitución de la Constitución en Colombia, en virtud de la cual pues no proceden reformas a la Constitución si se desconocen ciertos elementos sustanciales que identifican el régimen constitucional, o de la doctrina, digamos, los elementos básicos de la Constitución en la India, en la que se relacionan el desarrollo de ese tipo de doctrinas con la existencia de sociedades muy diversas, afectadas por todo tipo de conflictos sociales y diferencias culturales, pero al mismo tiempo en las que, o sobre todo en las que los valores democráticos no han terminado de arraigarse, no se han consolidado. Por eso no es extraño que, por ejemplo, en Alemania, tan pronto comenzó a funcionar el tribunal alemán, pues se desarrollara esa idea según la cual los derechos fundamentales son intocables, sin que sean estrictamente fórmulas pétreas en estricto sentido, ni siquiera el pueblo podría modificarlos. Y en Alemania tienen toda la razón de ser, pues justamente el pueblo eligió a los nazis y el pueblo avaló el régimen nacionalsocialista. Trasladándolo pues, a culturas, a sociedades como la nuestra, la de la India, o la sociedad, pues, o Colombia, en donde no terminamos de resolver nuestros conflictos y de aprender a convivir sin matarnos, instituciones como esta, doctrinas como esta, posiblemente serían una herramienta en las que desde el punto de vista del derecho constitucional, en cierta forma, se trata de imponer una democracia, un régimen democrático, la convivencia democrática, logrando que ciertos elementos esenciales de un régimen democrático y del Estado de Derecho estén, digamos, a salvo del juego político. Esa era la idea. Y entonces, bueno, en principio, Siddharth y Mena elaboraron bastante al respecto. Me parece muy, Siddharth resaltó, digamos, una situación que se dio, el que he comentado bastante con ocasión de en el periodo de Indira Gandhi, y me llama la atención sobre un punto que me parece importante, y es que sería posiblemente el contraargumento a la idea que tengo yo, y es que muy probablemente al establecer, llama la atención, ¿no? En el momento en que se establezcan estos elementos muy formales, muy concretos, como intocables, como se impongan, digamos, presupuestos de la democracia liberal a la occidental sobre sociedades para las cuales esto no tendría ningún significado. Obviamente eso sería ya, yo diría que desde mi punto de vista, pues ahí presto mi opinión, de pronto ahorita la puedo compartir con Med en inglés, ya un abuso pues de esa teoría, porque justamente sería la aplicación de esa doctrina, pero mordiéndose la cola en contra de ella misma, que es un poco lo que yo veo, como comentó Meda, en Europa ahora mismo, la discusión sobre todo en Francia, con la prohibición del velo islámico, que es muy curioso, es contradictorio que en nombre de la libertad se vulnere lo que básicamente es una muy radical libertad personal, y es cómo vestirse, sobre todo cuando expresa convicciones religiosas. Le comento a Meda rápidamente.
Sí, por favor. Sí, claro. ¿Cómo no?
Meda, I just wanted to comment about your commentary is regarding the idea that these institutions or doctrines like the basic elements of the Constitution could be used to impose values of liberal democracy from the conceived from the European point of view. Well, I think that that is a possibility. It's also a risk, but it will be, I think it will be even something, a contradiction in the same principle. It's the case that you mentioned, especially in France,
Yes.
that the idea to restrict the prohibition of the how do you call it, the
headscarf.
Yeah, for Muslim women, that is a contradiction in the principle. It is absurd that in the name of liberty,
exactly.
you prohibit someone to use something that is an expression of your deepest conviction.
Exactly.
So I agree completely with you.
Yeah. No, and it's very nice that it's very nice that you said it's contradictory, because this word was not coming to my mind, and now I realize, yes, you're right. It's on a if you look at it in a purely theoretical basis, it's strange. It's contradictory.
In the name of freedom.
Yes, exactly. Yeah.
Thank you very much. Thank you very much.
Thank you very much.
If I can just intervene, like on this headscarf ban, I think it was questioned on the ground that it violates the principles of liberty, but the ban was imposed on the ground that it violates fraternity. So they said that it might be a problem because it was first a question that, I think the first question was with regard to that it is a choice of a woman. But they say that if you come in such an appearance, then you not allow other person to come and talk to you because of your appearances. So that violates the principle of fraternity, which the French society cherish, which is as one of the features of the constitution. So I think they did something with the word. They said it's violative of fraternity, and though it is fine with the liberty.
Thank you very much.
Thank you very much.
Aplaudimos, hacemos así. Thank you very much, both of you, for being here in our seminar. It's a pleasure. Thank you, Siddhartha. I know that it's very late in India. It's about around 12 o'clock, midnight, okay. And also,
wow.
I see that he drink tea or coffee. I don't know.
Yeah. Yes.
To be awake, and thank you all the public, and I hope that we can do more of these seminars related with the two countries that are far away but are very similar in many problems and issues.
Yes.
So, yes, it was a very good seminar, and also it was a pleasure to have you both here. And I hope that you visit Colombia, and also that we can do another thing like this kind of seminars related with other issues.
Yes, definitely.
So we have like please, Sarita, you can show the poster from the next seminar. So will be va a ser un seminario de la revista Derecho al Estado, va a ser el primero de un número especial que vamos a hacer para celebrar los 30 años de la Constitución, y va a ser sobre los séptima papeleta, va a ser sobre algunos de los integrantes. Está Darío, que hizo la pregunta, que fue uno de los estudiantes de la séptima papeleta, que promocionó, va a estar aquí contándonos. Gustavo Salazar, Catalina Botero, Oscar Ortiz, Alexandra Torres, Fabio Villa, y nos va a contar un poquito sobre cómo fue el movimiento, cómo fue, digamos, todo el proceso para que unos estudiantes promovieran una nueva constitución en el año 90 y que se diera finalmente en el año 91. Entonces, gracias Darío y a todos los, digamos, miembros de la séptima papeleta. Esto va a ser a las 6 de la tarde nuevamente el 1 de diciembre, dentro de 8 días, con inscripción previa. Y at the end we are showing a poster that we are going to have, like the next seminar will be related with the the 30 year of the 1991 Constitution. So it was a movement of students that Darío is one of the members. He was in the 1990s, one of the students who promoted a ballot, a 7 ballot for make possible a referendum to make a new constitution. So will be next Tuesday. At the end, we are going to take a picture. We know that here are the Meda family also. Está el papá de Meda por acá. If you can, please open your cameras and we are going to take a picture as a souvenir. If you can open.
I think maybe it's very late in India. Probably he's in bed, but if you want.
Okay, don't worry about it. So, Margit, Juliana, Yvette, Alok, Alexander, Andrea. So, Sarita, ¿nos puede decir cuándo toma la foto? So she's going to count. Sara.
Okay. 1, 2, 3. Perfect.
Okay, thank you very much. And
thank you for this.
Bueno.
Thank you so much. This was very, very enlightening.
Okay,
bye. Thank you.
Bye.
Thank you very much.
Ciao. Good night.
Have a good night.